So, I'm Gary. I'm a magistrate in Portsmouth Magistrates Court. I sit in the Adult Criminal Court and the Family Court, and I've been doing that for, I think it's 80 years. My colleague.
80 years?
8.
Oh.
8.
Sorry.
80 would be impressive, or I look very good for my age.
I'm Rob Stone. I sit in Adult Court in Portsmouth, and I've been doing it for 2.5 years.
So we are part of a group of magistrates that do a community programme, and we just come out and talk to people in the community about what we do, with the intent, purely the intent, of raising awareness of what we do and the kind of things that occur to us. We do a lot of it to educational establishments of different sorts. But what we try and do in these sessions is try and give you an experience of what it's like to be a magistrate. The first part of this, we're going to do some questions about what we do and who we are. The second part, and the bulk of it, we're going to do a trial where you will decide whether someone is guilty or not of a knife crime offence, and if you find them guilty, you will sentence them, okay? But to get you warmed up for that, as to how magistrates work, we're going to do a couple of other things first. Okay? So, magistrates work in threes. Do you know why we work in threes? Any ideas?
So that if two of you may agree on the verdict or something, or just a majority decision.
Correct. That is the prime reason we have 3 of us. So if we don't all agree, you tend to got 2 that do. Yeah. It also brings 3 different perspectives on things and can make the decision. As a 3, you are now a bench. You are an individual unit in the court. You now make decisions. You're all equal. The person in the middle of your 3, if you've got a 3, is known as the presiding justice. They are the chair of the court. They are the person who speaks to the court with your decision, and the court speaks to them. Okay? And they even if they disagree with the 2 other people, they give the majority decision. For completeness, the people on the outside are called wingers. Exactly the same degree of authority, judgment, decision, everything is the same. All right? So, as the presiding justice, the person in the middle, you've got 2 jobs today. Job 1 is to make sure for every question and decision you've consulted with your colleagues and you've come to a decision of some sort. And the second is, when I ask you what your decision is, you tell me on behalf of your bench. So the wingers don't speak to us. If you want to be the presiding justice, argue with your other person and become one. So, first question. Rob and I do this. We're in court. You come into court, you'd see us at the top, elevated, making decisions. For doing that, how much do we get paid? Anyway, so you go 0, so you think we do it for nothing?
No.
Okay. Zip? Because you were here last time, you would have told me no.
Yeah.
Voluntary.
Voluntary.
Don't get paid.
0 but paid expenses.
Oh, I like the bill. Yeah, that's good.
Yeah, same 0 but expenses.
And you're all correct. We are volunteers. I don't know how many of you knew we were volunteers before I came last time, but most people have no idea that we're volunteers. So we are just members of the community that come in. We do get paid expenses. If I do a day in court, I will walk home with the princely sum of £10.43. So it is not a thing to do for money. Okay? Second question. How legally qualified are we? How qualified do we have to be a magistrate in a court of law? Magistrates' courts work very quickly. On a normal day in court, we could have 30 or 40 cases, so we're going to go quickly. So, how legally qualified do we have to be, sir?
No qualification
At all?
at all, but
Not.
supported by advisors.
Oh, okay. So not even an O-level, a GCSE, English, anything?
Okay, no qualification related to law, but
Okay.
I guess
GCSE? Okay. And is that your view or your bench's view? I'm only teasing. How about you?
We said probably like minimal qualifications, like maybe like GCSEs and stuff, but pretty low.
But no law?
Yeah, no, not really.
Okay.
yeah, no qualifications.
At all? Not even reading, writing, maths, nothing?
As long as you can read, because you need to read, obviously. But
Okay. So, do we need a qualification in reading?
no, well, not really. Because then
I'm only asking, because in a court you're very clear about things.
Yeah.
How about you, sir?
No qualifications.
At all?
You need a general education to be able to read and understand, and you will be trained on job. You don't need a law qualification.
Okay. Rob, how long did you spend taking your law degree?
0 days.
Correct. We do not need any legal qualification at all. We actually don't need any qualifications of any type at all. Not a GCSE, not a NVQ, nothing.
I would qualify that slightly,
Okay.
is that you fill out quite a extensive application form. So if you couldn't read or write very well, that would show up.
Indeed, it will be a difficulty, but then again, reasonable adjustments are made because you can be a magistrate and be deaf or blind or these things, but no qualifications are required. And we are supported by a legal advisor. The court is full of lawyers, we're just not any of them. So if legal advice is required, which it often is, we get it from other people in the courtroom, either the prosecution, the defence, or our own legal advisor. We do, however, have lots of training. So we're trained in how to apply the law, how to make decisions, how to run the court, all those things. So you don't just pitch up out off the street one day and turn up and be in court. You go through a process, an application, training, and then you're in court. Okay? Right, different sort of question. What kind of offences do you think we deal with? So just think of 2 or 3, because if a bench picks your one, we want you to give another one. What would we cover in a magistrate's court? Okay. Your worships, which is what you're called as magistrates. We are called many other things in court. They're not all polite. I've been called Your Highness, My Lord, Judge, but your worships, your Royal Highness, we call that. And I've been called lots of things that I wouldn't want to repeat on a Saturday afternoon to anybody, but your worships is what you are officially called. So, what offences might we deal with? Give me an example.
I have no idea. I'm just thinking.
Okay, I can come back to you. How about you?
Shoplifting.
Shoplifting. I was going to say we do a lot of shoplifting. We get a lot of shoplifting offences in front of us. Yes, we do. A lot of that.
Fraud.
Fraud.
Yeah.
What sort of fraud do you mean?
Just like identity fraud.
Identity fraud. Okay, serious stuff.
Can we add to that?
Yes.
Any form of criminal offence.
All criminal cases, I'll say probably 95% of all criminal cases.
Everything.
Yeah,
So
all-
murder,
yeah,
rape,
correct.
treason,
all the high-profile
piracy,
cases go to the
everything.
magistrates courts
Okay,
first.
thank you. I'll come back to that. Fraud, yes, we see a lot of fraud. Most of the fraud that we see is much simpler than identity theft. It's somebody nicks your card, that's theft. They use the card, that's fraud. So you get those are the kind of things that we get kind of stuff. So thank you. How about this bench? Who's your chair?
We said all crime.
All? Okay.
Yeah.
So everything.
Yeah.
But then you were here last time.
Yeah.
We said sort of like everything, sort of like low crimes, like other sorts of crimes, generally.
Everything.
Yeah.
Okay.
95% of crimes except murder, rape, and all the serious stuff.
Right, okay. So all of that is accurate and correct. We also do things you might not have thought about. So we also do RSPCA offences, so cruelty to animals will come to the court. Environmental offences will come to the court. Lots of driving offences will come to the court. If you don't take your children to school, then the parents are brought to court and we do that. So the prosecuting authority isn't always the police and then the Crown Prosecution Service, which it is in these criminal matters. It can be other organisations. So if you don't buy a ticket on a train, the train company brings you to court and that comes to us. So lots and lots and lots of things. If your local takeaway has got cockroaches roaming around its kitchen and the council decides to prosecute them, that comes to court to us. So all these things. Now, you've already told me, many of you, because you remembered well from last time, so this is a good gold star, 95% of all cases in this country are dealt with in the Magistrates' Court. 97% start with us, 95% end with us, and the 2% difference are things where we haven't got the authority to deal with the punishment. So like murder, even those start with us. They come to us first, and then we send it to the other court where they've got a greater sentencing powers. The small percentage that we don't see at all are things that we generally don't know about. So treason, piracy, espionage, lots of terrorism type things, they're not held in public court, so we don't get to see them and they don't come to us. Okay? But all the crimes that you can think about, basically, they come to the court. Now if you think about it, that means we have a system where 95% of all criminal offences in this country are dealt with by volunteers with no legal qualifications who do not get paid for it. That's our system. It's a unique system. You will find magistrates in other countries, but they're all paid jobs. They're like judges. The volunteer type aspect of it is unique to here. Okay? And the idea is that we are ordinary members of the community. We are from the community, we pass justice into the community, and we represent the community. So we do all those things together, which is part of the reason why we're here today. All right? Last question before we get you involved in a knife crime case study is, what kind of sentence could we impose on you if you were found guilty? Discuss in your bench again. Crown Court, they will sentence you and they can do it to life.
If you don't do anything within that time, you still will have the record of the crime you committed, but you'll be free
Oh, yeah,
to,
yeah.
Yes.
will be free to, like,
But you automatically, we'll know what the suspended sentence was applied for, and if we, or let's say it's a district judge sitting in the magistrates court, to say, right, I'm invoking that, and you're also done for the crime that's been brought in for again.
And how long is that in your records? Is it forever or does it have a time?
Yeah, I mean, the kind of sentence we impose, they all exist in your criminal record forever. There's different circumstances in which they are available or not to people who ask, because it depends on the Rehabilitation Offenders Act and all those kind of things. We don't control that at all. The only thing that we would do that does not generate a record if you don't breach it is a conditional discharge. So that warning, if you don't do anything, then that disappears off the record. All right. So, and I'm whistling through, but I'm doing quickly because we're going to move on to the case study, the trial now. So again, these are the kind of things that we do, and we can go into depth on lots of different things with your community group based on what's interesting to those people. But now you're going to do a trial. Now, magistrates' trials are nothing like what you see on a TV for, again, usually in American courts. You are both judge and jury. There's three of you. You will hear evidence. Almost all the evidence we get in a trial is somebody standing up and talking to us. We see some CCTV, some photographs, but not many. Most of it, you just hear evidence from multiple people, and based on that evidence, you form a view and make a decision. Okay? So we're going to give you a very short case study. Rob's going to read the prosecution. So listen to that case. I'll read the defence case, and then in your benches, be ready to answer two questions. Question one is, do you find the defendant guilty or not guilty? And two, why? In a sentence, not a legal answer, just why do you reach that decision? Okay? Okay, Rob, fire away.
Quick, most important thing when we do a trial, we have no idea of their previous convictions. We see just that.
Because that was my question. My question is, like, before someone comes in front of you guys, do you have a record of everything they've done previously? Or you don't get given anything?
There is a record in court, but we don't see it prior. We can only judge you based on the evidence that's provided on that day.
That is the case for a trial.
Yeah.
Because in a trial, we're deciding are you guilty or not.
Okay.
If you've pled guilty and you're here for sentencing,
Yeah.
then we know all about your previous history.
That will be given to you.
Yes, we would know that because it forms part of our decision process.
Right.
If you've done something 50 times in the last year,
Yeah.
your punishment will be worse than if it's the first time you've done it.
I see.
Yeah. And how long do you have to make that decision?
How long? Well, we take as long as we need to, but most sentencing decisions will take no more than 5 minutes, sometimes 30 seconds. A trial decision, again, they might be 10 minutes, but we might listen to a day's trial. It depends how agreed we are. If we all immediately agree, it can be 2 minutes. If we disagree, it can take a long time. So we have to see. So, and we'll see how it goes. Now, I should just say that the crime that this person is charged with is possession of a bladed article in a public place. So a knife in a public place. That's the charge, which is, pay attention, your wishes.
Joe was arrested outside a convenience store after being identified by a security guard. He was seen to walk away with a joint of beef, £15 cost, hide it inside his inside jacket and walk outside the store without paying for it. This was clearly captured on CCTV. The security guard asked Joe to stop but was ignored. By coincidence, there was a police officer taking a rest break nearby and the security guard alerted the officer. The officer gave chase and grabbed Joe by the arm to stop him. There was a brief scuffle. The joint of beef fell out onto the ground from his jacket, as did a kitchen knife, approximately 6 inches long. Joe was arrested on suspicion of shoplifting and being in possession of a bladed article in a public space. As the joint of beef was recovered, the shop decided not to press charges for the shoplifting. Joe is being prosecuted for the possession of a knife, and that comes into court today. He was released on bail and attends today on a summons. When arrested, Joe gave no comment interviews and pleads not guilty today.
That is the case for the prosecution. The defence, Joe accepts that he took the beef. He says his family is struggling to cope financially and he routinely goes hungry. He wanted to surprise his mom with some nice food to cook, but realises that was a stupid thing to do. He's very grateful to the store for not pressing charges. Joe denies that the knife was his. He says it must have been dropped by someone else before he was grabbed by the police officer. He also says that the jacket he was wearing is one he was wearing for the very first time that day after buying it from someone he met at a gig. The jacket has a very large inside pocket and he would not have known if something was inside it. Joe maintains he did not put the knife in the jacket. Joe is 20, lives at home with his mother and 2 younger sisters. So your worships, the task before you now is, do you find Joe guilty or not guilty based on the evidence that you have heard? And in a sentence, be ready to tell me why. So please deliberate. If you have any questions, put your hand up. Right, your worship.
So you 100% yeah.
Your worship.
If I was sat there, I would just yeah.
Your worships. This is where I needed that gavel, which if I come next time, I'll bring a gavel. I'll bring a hammer or something. Anyway, so I'm going to go around and again, just tell me, do you find Joe guilty or not guilty? And then just in a sentence, why do you come to that decision? All right. So we'll start here. Guilty or not guilty?
Guilty.
And why do you find Joe guilty?
Because there's 2 witnesses to back up the same story. Despite the fact that he bought the jacket beforehand, he still is within possession of a knife, which has fallen out of his pocket post committing another crime beforehand.
Okay, thank you.
We were quite torn, but we said guilty just because, like, the story of like, oh, like the knife was like the pocket's really big, and the knife was in, he didn't realise. Like, if the pocket was that big, then the knife probably wouldn't have fallen out in the first place. So I think he obviously knew that he had the knife, and obviously the crime is possession. So I think, yeah, he knew he was possessing a knife. So yeah, guilty.
And did you all agree on that?
Yeah, well, we were quite torn because there's both sides, but we said guilty just generally.
Okay.
But, yeah.
That's fine. That's good. That's fine. Thank you.
We say guilty because the offense was possession of a knife in a public space. He had possession of a knife in public space, so we say guilty. However, given the circumstances, if it's his first crime, we don't know that, to have like...
Well, don't worry about sentencing. We'll come to sentencing later on. I know I went past you. Did you have a view?
Because I don't know which group I belong to. I said not guilty.
Okay, and why did you say that?
The reason not guilty is they saw him on CCTV with the meat. But when he comes out, put the meat in the jacket fell off. Sorry, the meat fell off with the knife, and there was the police officer. So you can't prosecute until you have the evidence of that knife belonged to him, and he got the jacket. I don't know, he bought the jacket, the knife could be there, so you need fingerprints to make sure that he is guilty.
I'll answer those points in a second, but thank you for that. It's very helpful. So,
Guilty.
because?
Because he's in possession of a knife, and his story about how his family can't afford food and he's going hungry, that is believable, but he prioritised buying a jacket instead of using that money to buy the meat. So it's
fair enough. Interesting. Yes. Thank you.
It's
Yes.
good.
Okay, we said guilty because it's just excuse saying he doesn't know the knife was in the jacket. Because if something is in your jacket, if you bought something, the first thing is check if it's good or not, so you can find out easily there is something there.
Okay,
So,
thank you. Now, did you end up not agreeing with the bench
Well,
of
we
two?
were kind of part of this group.
But I think Ruby and I would disagree.
Okay,
No, say your point, because
this
I
is-
say guilty.
Yeah, so it's interesting. So this is we try and avoid running a trial with two magistrates. We do sentence with two, but we try and avoid running it with two for this very reason. Because if they disagree, what do you do?
Yeah.
Now I've been in that situation, and what we did was I went, well, obviously there's some doubt, therefore I'm going to say not guilty as well, so he becomes not guilty because there's doubt. Because obviously you can't upgrade your doubt to not no doubt. So, but that's why we don't have two.
Right.
So that's the fact. And in a real court, you can't turn around to another bench and ask them to help you because there's nobody else in the court. So it's there. Now, a few points out of all that. Firstly, your intervention was really helpful. What you're dealing with as a magistrate, you're not trying to find the truth. You're not an investigator. What we're trained in is to make a decision based upon the evidence presented. That's all you can do. We often wish there was more evidence. We often wish, so isn't there some CCTV? Isn't there evidence of a card? Wish you'd ask this extra question of the witness, but you have the evidence you have. And it's the prosecution's job to prove beyond reasonable doubt that the person is guilty. The defendant doesn't have to prove anything. However, you can take into account a lot of things. So do you believe the defendant's story? Now, part of that is the actual story, part is how they delivered it in the witness box. Obviously you didn't hear that today, I just read it out. But if you don't believe his account, then you're not going to agree with what he's done. Equally, you might say, well, if all that's true, Joe, why didn't you tell that to the police when they arrested you? Why did you just do no comment until today? You can take what's called an inference from that, the way you do it. But you don't need corroborating evidence. You have the evidence you're given in the courtroom. And if you don't think that's enough, they're not guilty. If you think it is enough, then you find them guilty. Right? So it's not like evidence of somebody, what they see, what they account, what they tell you is evidence. It's just a different sort of evidence to having fingerprints or whatever else it might be. Now again, you would expect that if the police have got the knife and it's Joe's, they would have tested the fingerprints and they would know, and if that was the case, they would tell you in the court. But none of that happened. So you can't assume anything by its absence. You just have what you have. Equally, I've done this case study a lot and many times. I've never heard that analysis, and that's very clever analysis. That judgment about, so you bought a jacket but you're nicking food. What's going on? Interesting kind of perspective. But again, not evidence. It's just part of your, do I believe what he's telling me? Because in the end, although everyone in court promises to tell the truth, they all take an oath. Broadly, half the people we see lie. Because otherwise there'd be no trials. Because you wouldn't have anything going on. Okay? So, now let's imagine everybody has found him guilty. You know what our sentencing powers are. What sentence do you impose on Joe as a magistrate? So you've all found him guilty, even you undecided twosome. You've all found him guilty. What's the punishment? What's the sentence? Decide in your bench. We'll start over here then. So what sentence do you impose on Joe?
Community service.
Okay, so unpaid work in the
80
community.
hours, yeah.
How long?
80 hours.
80 hours.
Yeah.
Okay, thank you.
1 year sentence and community service.
1 year prison sentence. So 1 year prison sentence and unpaid work in the community.
Yes, so he will realize he could work to get money to buy food.
I see. Okay, thank you. So a year in prison, and when he comes out, 80 some hours of community service.
Yes.
Thank you. A conditional discharge.
Yeah, for 12 months.
Suspended sentence.
Yeah, I would say give him time. He says he made a stupid mistake with the shoplifting. Obviously, we're not pressing charges on that.
Yeah.
And he claims innocence with the knife crime. So I would say we give him conditional discharge, like a suspended sentence of 12 months. Should he commit another crime, he'll be charged. And this is like an opportunity to learn from the mistakes he says he made.
So you're giving him a final warning, conditional discharge, no punishment today, but if you do anything else, you're going to get
charged for
that.
that crime.
Okay, thank you.
We were literally the same. We said conditional discharge for maybe like 6 months to a year. Then we said maybe some community service as well, just so he like it's not just like feeling like nothing. Like of course he has to watch his actions.
So you do some unpaid work as well.
Yeah, but not like loads obviously because he's already
So it'd be about 80 hours over here. Would you be in more or less than that?
less.
Less than 80 hours.
It's over 18 months.
That's actually a good idea.
Okay, thank you.
Probation, so community service.
Yeah.
And sorry guys, I need to add what's your name? Sorry, Alvin. Alvin, very smart. I add as well what Alvin said.
This is as magistrates, we learn from each other all the time. So that's very good magistrate skills.
So basically,
Let's imagine that you're in a bench of magistrates and you thought he was not guilty, and your other two colleagues thought he was guilty. You've had a discussion, and the bench now says he's guilty.
Yeah.
You then sentence him as a magistrate as though you found him guilty. You don't sit there going, I don't think he's guilty at all, therefore I want sentence to be less. You're now a bench of magistrates. You are collectively making a decision. So what you did is spot on, even though he's thinking, what, you found him not guilty? What you've done is the way that we would do it.
Okay.
Now, two things about it. A lot of you have given him 2 punishments. I'm afraid you can't do that. So you can send him to prison, and you can make him do unpaid work, but you can't have him do both. Right? So you have to pick a sentence, you can't have 2. No reason why you'd know that, but that's how we do it. However, for a lot of crimes, we have what are called sentencing guidelines, and in certain crimes, Parliament lays down some minimum expectations of what happens if you're found guilty of a crime. So for the possession of a bladed article in a public place, never mind using it, or threatening anybody, the minimum expected punishment as a starting point is 6 months in prison. So that's what the magistrates would start with. So they'd start their deliberations saying what the law is it expects 6 months custody sentence. Now, it is not a you must do that. There's then factors, there's circumstances, you make a decision around it, but that's where you start from, and then you work out whether in this occasion should be more or less, could we suspend it, all those kind of things. But the starting point, first offence, 6 months in prison. Okay? The range, if you go outside the range, then you're into, well, why are you doing that? The minimum part of the range is 3 months. So the expectation, if you're found guilty of any offence involving a knife, just having one, even if it hadn't dropped on the floor, if it had just been found in his pocket, 6 months in prison. That's the starting point of the sentence. Right, now, unfortunately, your worships, the prosecution forgot to tell you something very important. So could I ask you to listen to the prosecution, then you might want to reconsider your sentence.
Okay, I forgot to inform you of this. This is the second offence in 18 months. The previous sentence was 3 months imprisonment, suspended for 9 months. The new offence was committed several months after the suspended sentence had ended. So he hasn't breached his suspended sentence, but it is a second offence.
So he's done this before. Last time he avoided going to jail by having the sentence suspended for a period of time. That suspension period ended, and a time later he's committed this offence for which you found him guilty. So now you know that, which you would know before you sentence. Would you like to change your mind on what your sentence is?
Yes.
Have a thank you. Have a discussion in your benches, and we'll come back to it. So now that we know Joe has done this once before, and this is his second offence, what are the sentences?
I would say the sentence would be 18 months imprisonment, but I would make the range a year. So should they like do well in prison, good behaviour and everything, they have an option to get out after the first year, but serve a year minimum in prison.
Okay.
And the reason is because they obviously had a suspended sentence. So they were thinking about it, you know, it's premeditated. They were smart enough to adhere to their suspended sentence. However, not too long afterwards, they then went and committed another offence. So it clearly shows this is not a mistake like they're claiming. It's a pattern of behaviour that has been thought through.
Right, so 18 months in prison, but can you serve at least a year and then get a chance to come out? Okay, thank you.
6 months in prison.
6 months in prison,
Yeah.
straight to prison, do not pass a go, straight 6 months in.
straight.
I keep 1 year in prison because they plan their action carefully. Yeah.
Thank you.
We said 6 months because if he's done it before, clearly the suspended sentence didn't really work, so he needs to actually like serve some time instead of thinking he's just going to get away with it again.
Okay, thank you. Dramas group. Whoever's chair there.
6 months without
6
bail.
months. 6 months without parole.
Bill.
Without.
No. That was
Is it 1 year?
Parole.
6 months without parole.
Yeah.
So 6 months without parole. I was just checking that's what you said. That's
Yeah.
what I'll come back to that in a second.
8 months.
8 months. Okay. So first of all, remember, what are your maximum powers as a magistrate?
6 months. 6 months.
Sorry?
What are your maximum powers as a magistrate?
6 months.
How long can you send someone to prison for? 6 months. So if you were thinking it's more than 6 months, what you do in practice is you send it to the Crown Court, and the judge at the Crown Court will decide what that sentence would be. Now, it doesn't mean that it'll be more than 6 months. The judge will assess it and then make their decision. But you would say it needs more than we can, so you send it up. So in practice, if you thought it was a year or 8 months, you can't send them to do that. You have to send it somewhere else. The question about how long they spend in prison is not a matter for you as a magistrate.
Right.
So you send them to prison. The prison rules about when you are released are driven by entirely separate things. At the moment, if you behave well, you can expect to be released after half the time on licence, automatically. But then for the rest of your prison sentence, you can be returned back to prison if you breach any of the licence conditions that you have and serve the rest of your sentence. And once you are out, there's an extra year where you're under supervision, and if you do anything, you're going to be called back to prison. So the prison sentence, if you like, hangs over you for a year after you've come out. But none of that is a thing that we as magistrates do. We just say, this month, this much time in prison, and then the prison service, the probation service, all those people then decide what happens after that. They also decide what kind of rehabilitation support, if any, occurs in prison. Because obviously we've just sent to prison, that's it. Okay? Now, this question about the suspended sentence thing is quite interesting because you have to be careful not to make assumptions. So it's possible that Joe went, I'm on a suspended sentence, I'm going to keep my nose clean for 9 months and then start again. That's possible. It's also possible he carried on exactly as before but didn't get caught.
Yeah.
You don't know. It's not evidence that been produced, so you can't use that as a factor. You could say the suspended sentence worked because during the time of the suspended sentence he committed no crimes. But again, he might not have been caught. We don't know. You don't know those things. So they're interesting thoughts, but they're not a factor that will drive the sentence. Okay? But what you've done is exactly what magistrates do, which is you take notice of the previous offences and you increase the punishment. It's called an aggravating factor. And that's what you all did naturally, which is why you're all clearly naturally disposed to be magistrates, which is great news.
Oh. Any other questions?
Yeah, go on, you go, sorry.
Sorry. And what's the difference between like what you guys do in the jury actually?
There's a lot of difference. In a jury, you're in a Crown Court and you're only making a decision with 11 other people on guilt or innocence. So it's a big trial, you listen to it all, you make that decision as a group. The judge, who will be in the court, will decide on sentencing. So you are there just for that one trial, and then you're finished. Whereas we are magistrates and we are in, well, we have to commit to doing 13 days a year. We all tend to do more than that, but then we're in and we're judge and we're jury. There's no jury in a magistrate's court. That is a great question. And anyone can get called to be a jurist or a juror, and almost anybody can be a magistrate, but they're completely different things.
for someone who wanted to be a magistrate, how would they go about doing it?
I'm going to leave you some leaflets, so you can know, but you would Google, I can be a magistrate, and that will take you to a website which will tell you all about it. But I will leave some leaflets and stuff if you're interested. You can have a look at it. The process of applying, which is all online as you would expect, helps you decide whether or not it's for you.
Yeah.
Because it asks you questions about yourself, it's got a process and all those kind of things. So you can look at the website, explore it and all that kind of stuff, and if it is for you, great. Okay. All you have to be is 18 to 70. You can be a magistrate till you're 75, but you have to apply before you're 70. As you know, you need no qualifications. You can't have a serious criminal record. So if you've got a minor criminal record, like motoring offences, it will be considered and stuff, but all that gets assessed. And you need to either be a British citizen or have a permanent right to live here. Apart from that, anybody can apply.
Generally, part of your application, they ask you to go in and sit and observe for 3 or 4 days, and then you, on your application, you say how that went and what you thought, and it gives you an idea of, do I want to do this type of thing? So.
I've got a question. You may have a permanent right to reside. Say you come in the country for 1 year, and you've got a permanent right to reside. Can you be a magistrate?
It would take you more than a year to get through the process. It took me, COVID caused me a problem because there was a sort of hiccup in training. Yeah. But from application to actually sitting, it's probably about 18 months anyway.
Right. Okay.
Yeah, the process is not quick, but
is the prosecuted in the court while the magistrate the judge the judgment is in the court, the prosecuting person. The reason why I'm asking that is because what if you give a sentence and you see the prosecutor in Asda, maybe he's not guilty, and what kind of security or safeguard do you guys have as a magistrate?
Well, it's a question often asked. To be honest, it's very rare. I mean, we often get sworn at, as you can imagine, but, and we get people say things to us, but an actual real threat is an extremely rare thing. We do have separate entrances to the public in the courtroom, and on the odd occasion that I've bumped into somebody outside the court, it's been nothing other than a convivial conversation. And obviously most of the time, the people that might be interested in getting revenge have gone to prison. So you have to wait, they have to come out. They don't know who we are. We don't say, hi, I'm Gary Price, here's where I live, and all that kind of stuff. We're just a magistrate. And to be honest, what we believe happens is people don't really see us as people. It's just you were they hate judges, you were a judge, and I hate all judges, frankly. So it's not a thing that if you were considering it should put you off, because it's just not a thing that bothers us. In the court, there's all sorts of security, you can imagine. If you were to go into the courtroom, you have to go through an airport-style detector thing, and it's extremely strict what you can take in. So,
part of my process of deciding whether I wanted to do this, I had a friend who was a magistrate, and I asked him that very question. Have you ever bumped into anybody that you sent to prison? And he said in 17 years, just once, and it was just a nod. He recognised me and moved on. So. I'm not saying it couldn't happen, but it's very rare.
It's happened more to me actually in family court, because I was in family court. People don't send people to prison, so you get disgruntled parents, and they tend to loiter outside and debating with their other half. Debating is probably not the right word, but you know what I mean. And they recognise you because it's a much more intimate experience in the family court, so they do get the sense of, oh, I know you. But even then, those conversations are not the ones that are not aggressive. They're just disappointment. And if they were aggressive, I'd just love it. I mean, there's no great strategy to it. I'll just be out there and seeking help.
And also, to be fair, the consequence for them, if you were to do anything to you, that much.
Oh, it was serious, yes. But suppose people don't commit crimes thinking they're going to get caught. So people don't have that consequential thinking, because if you were that kind of person, you wouldn't be the kind of first person. Anyway, we're stopping because I'm running out of time. But That, as I said, we did whistle stop of what we do.
Yeah.
We tailor things to the audience and the group, so we discuss in advance what it is that you would want to get from a session. We can do more of the about us, we can do more about certain crimes, we can do more about probation, we can do more about offences. It depends on, as long as we know, we can tailor it. But what we always try and do is do it in that style of interaction, because we found that's what gets people interested and engaged and ultimately learn more from it, as opposed to us just giving you a presentation which even I'd find boring to give. So, God to help you. Thank you all very much for your participation.
Thank you.
And your
Thank you for your time.
Thank you so much.
Yeah, it's been
Thank you.